This is an interview with John McCarthy for the SEC Historical Society's Virtual Museum and Archive on the History of Financial Regulation. Today is July 20th, 2022, and I'm Kenneth DURR. John, good to talk to you today.
Thanks for having me.
Well, let's start out with some background. And we were just discussing before we got on camera, and I found out that you're a native Washington, D.C. type person, which is remarkable in and of itself. So tell me where you ended up going to college, how you got interested in the law, that sort of thing.
Sure. So I grew up here in D.C., went to Churchill High School, and wanted to study engineering in college. And so that led me to the University of Michigan, kind of one of the better engineering programs. And so I went there, and again, I originally went down the engineering path, but then I also had a huge interest in, when I was able to take other courses, which was hard in engineering, I took an economics course that I frankly fell in love with. A professor and I really enjoyed my experience with him. So I then changed my path a little bit to get a joint degree in engineering and econ, and that was extremely unusual for engineers to do anything unusual, especially in Michigan. So I got an econ degree and an engineering degree, and with kind of what was increasingly my passion in economics and that whole world, I decided to get a master's in finance from the London School of Economics, and that was, again, a wonderful experience. Not only a great school, but kind of in the middle of London as a young kid. Obviously, really enjoyed that experience. Then from LSE, I went to work for a bank in London. Again, enjoyed that, but ultimately, I think I decided I don't want to live the rest of my life in Great Britain. So basically, I decided, as part to kind of go back to the States, and as part also to kind of pursue a professional degree. My dad always kind of encouraged me to have a profession, kind of the typical growing up poor type attitude, get a professional degree. I decided to go to law school, so I went to University of Maryland. And then coming out of law school, again with my econ and finance degrees from Michigan and LC, an obvious choice was to pursue a career at a financial regulator, and the SEC being the penultimate financial regulator. I also kind of, at LSE, kind of gained a passion for markets and market structure, and again, so my goal was to get a job at the SEC. It was kind of all roads lead to Rome, and that was kind of the case, and I was lucky enough to land one in the Division of Market Regulation at the time. So
you did some time as a law clerk as well, right?
Oh, that's right. Good point. Which is typical for law students coming out of Maryland. They would do a clerkship in Court of Appeals or Court of Special Appeals, and I did that in Annapolis with Judge Weiner. I think anyone who's clerked realizes it's probably literally to this day you spend a year going to work, and 8, 9, 10 hours a day you simply write all day. You write for a year, and there's no question that was, to me, one of the most valuable and helpful experiences in my career. It's unless you simply don't work, you're going to become an incredible writer. And I think that I'd look back at that experience and really see how valuable it was. I would have never predicted how valuable it ultimately would be. Yeah.
So it was 92 when you went to Market Reg?
That's right. Yep.
So tell me about life as a young staff attorney in Market Reg and the kind of work you were doing.
Yeah. So again, you're going into an environment. It's obviously all new, and you're young whippersnapper wanting to kind of work on interesting things and quickly learn. I clearly got lucky because early on I was able to, I think there was exams, the odd eighth exams and enforcement action were kind of in the middle of their duration when I joined the commission. So I think one of the early things I got put on as just an extra body was to listen to the market maker tapes, the NASDAQ market maker tapes, and try to identify issues around, I guess, collusion and persuasion and bullying around the odd eights issue. And again, obviously the actual work was crazy tedious. You would listen to tapes that would be incredibly mundane for hours and hours and hours. But like anything else, when you do a job like that and you actually find something, it's incredibly rewarding. And why that, for one of my first assignments, why it was so helpful for me is it literally gave me an experience a few people have. I was able to learn about how that NASDAQ, which was at the end of the day a phone market, how that NASDAQ over-the-counter market worked, and it was, because you're obviously inculcated through listening to the day-to-days of that market, but you also then are able to kind of apply what's going on in that market day-to-day with kind of what I recently learned in academia, and at the end of the day, it was a crazy market, right? It was a human-based, phone-based, phone-based market with ostensibly rules around firm quotes and firm and order execution protocols. But at the end of the day, if you have my experience, you would say that's the craziest market you could come up with, right? Have people call each other and harass each other and so it's a great experience because I was able to learn quickly, okay, how one of the biggest markets then functioning in the U.S., how NASDAQ stocks were traded, and I was able to also add value to the enforcement case because I did identify some instances where there was bullying and collusion and things like that.
So you're talking about being sort of in the early end, digging up the information. How about as that went through to create the rules after the odd eight scandal? Were you involved in any of that in trading and markets?
Yeah, I was. Yeah, I was involved in the sense that a lot of because I was in the exam program, so I was kind of lent out to enforcement. I was in the exam program, but I kind of again understood at a hands-on way things about the enforcement case. That was kind of questions that the policymakers would have. So I remember I was helpful in kind of collaborating with the policymakers and kind of understanding exactly what was found and things of that nature. Yeah.
Okay. So this was an unusual thing, the odd eights scandal that you got involved with. Talk about the usual stuff, SRO inspection and oversight, that kind of thing.
Yeah, so yeah, right. So that's right. That was unusual and obviously fun. It brings back good memories. The kind of day-to-day oversight inspection program was, I kind of came in. It was basically separated into two areas. The oversight program into two areas. One was the basic kind of, customer-facing, oversight of the SROs, and the other was the trading, the SRO surveillance around trading rule violations, insider trading, surveillance, and whatnot. So I was in the areas that kind of focus on the trading oversight exams, and again, for a young kid coming out with my experience, it was a great way for me to again quickly learn about not just the regulatory arms of the SROs, but also how the markets worked. And for instance, when we did oversight inspections of the New York Stock Exchange, opportunity for me to go from very low learning curve position up to much higher in a short period of time. So anyhow, but the run of the mill run-of-the-mill oversight program at that time was kind of what I call rote, is kind of a very, you would look at the last inspection and kind of, you would plan the new inspection based upon the last inspection. So they were kind of rote, kind of check the boxy type inspections in those early days. Yeah.
Did you get involved in specialized inspections where you're going in to look for a certain thing in particular? Because I know there were different types.
Yeah, I think over time. So I think in my early years, most of the inspections were, I think they were called routine inspections, and then I think it's really kind of not coincidentally. It's with Chairman Levitt coming into being chairman. I think there was more of I think my remembrance was there's just a mentality of being more aggressive, like rather than kind of focus on the routine inspection, is more like, hey, there's been issues or concerns around certain areas, so then the inspection program started kind of focusing in on I would call more targeted inspections, and some of those were generated through newspaper articles and almost criticisms about certain aspects of the exchange programs and the regulatory programs. So one that comes to mind was trade reporting. I think there was a perception that a lot of the trade reporting, the trade reporting was a mess, right? And especially in the third market and over-the-counter markets. And so that's really the first time I remember doing a targeted inspection of the SROs. How well do they ensure that the trade reporting is correct and accurate? And to say, again, I was young and still getting my sea legs, but it was a mess, right? I mean, the trade reporting was, it was very easy to find major flaws and problems. And, as a young attorney, like, I remember a friend of mine, we did an inspection of Trimark Securities, which is a third market maker that ultimately was bought by Knight Securities. But we did an inspection, and they weren't reporting millions of trades accurately, and then a friend of mine, Cam Smith, was, we were like, this doesn't seem right, and obviously it kind of turned into a big brouhaha. But I think it was the first example of the inspection program targeting an area, trade reporting accuracy, and finding major fundamental flaws in not only the actual conduct itself, but also in how well the SROs were managing their frontline regulatory program. In that case, it was more or less non-existent to some extent in the areas that we focused on. So
you looked at the New York Stock Exchange. Did you look at Amex, regionals?
I think on that inspection, the inspection program generally, yeah. New York Stock. So we called the listed exchanges as New York and Amex. A lot of you use kind of anachronistic terminology. Then we would look at the regional exchanges and their regulatory programs, and then the other big area was, of course, at the time, NASD.
Right. Were you involved in NASD oversight at all?
Yeah, the trading part. Yeah.
Okay.
Yeah.
Right. And you talked about Chairman Levitt. This is the period in which things are getting rolled up into OCIE.
Right. Right.
Take me back to when you heard about it, what your perceptions were. I would think that it would have been an interesting transition. Give me a little bit of how it was for the folks at the SEC at the time.
Yeah, it's again, thinking back, obviously as a relatively young in terms of not many years in, I guess 4 years then? When did OCIE start?
95.
95. Okay, so a couple years in, and I think I picked up early on that again, whether this is my recollection, whether it's kind of skewed by all the events at the time and subsequent. But I remember that the inspection program was clearly not the priority of the director, right? These were market reg was a policy making division, and the inspection program and also the exam programs, clearly were kind of running on their own. The leadership was the leadership of those programs, I think, were basically on autopilot, and the focus on the directors and the assistant directors was rightly so on policy making, and so that was my perception, and it wasn't a big deal to me personally, but when I first heard rumors about, I guess, Chairman Levitt wanting to kind of separate out the programs, it made intuitive sense to me. So, oh, that makes sense. It's probably a good way to kind of put focus on these areas, which I personally thought were critical and important because, as in my kind of initial foray into these inspections, I felt a lot of the SRO programs had major flaws, right? They were, some of them I would even say were form over substance, right? They weren't actually mandated by, which were commercial enterprises, to go root out securities law violations. They were almost just there, in my judgment, just to make because they had to be there, and the SEC, the self-regulatory SRO structure mandated it. But I quickly came to the realization that these, from the leadership from NASDAQ, New York Stock Exchange, and the regionals, they were not prioritizing regulation on their exchanges because at the end of the day, these were commercial enterprises. So I guess my long-winded point is having, I think Arthur Levitt, rightly so, felt that putting more focus on the oversight would obviously ultimately improve the regulation at the exchanges and the NASD.
And a certain amount of that oversight was looking at the structures, the institutions that were set up to self-regulate. And I think that's one of the interesting things is how much was OC or trading and markets and then OC, how much were you looking at that structure, whether they could check all the boxes, and how much did you actually go in and try to figure out if they were doing something wrong, if they were,
Yeah, so it's a great question. I think early on, but before OC and then once OC was up and running, the oversight program, at least on the trade, looking at on the trading surveillance side, was always just looking at and reviewing how the regulatory staff, we looking at their structure. We certainly would make comments around the number of resources they were employing. We would review and make comments or findings around how well they were doing their job, the amount of resources they were employing, and whether their overall kind of program structure made sense. The problem with overseeing kind of from the top down is and obviously all the findings that the program itself is making, it's you're never really sure, like, are they actually doing a good job? Are they actually following up on surveillance kickouts that that show some indicia of a trading violation, et cetera, et cetera. So when I become, I think, assistant director, I remember vividly talking to Lori about what had become kind of the way we did things. And I basically said, I don't think it really makes sense because we almost have to take what they say as factual, and meaning that they are following up on all, say, insider trading kickouts in an appropriate manner. And so I felt that from an oversight point of view, it made a lot more sense to at least test what they're doing, like go in and basically go into the front line and test what they're doing and verify whether we can find, in my example, insider trading that they couldn't, right? And Lori was, I remember Lori was incredibly encouraging to do that, but also like, how come we haven't done that earlier, of course. So, and I think as you look back, an oversight program is I think it's fundamentally difficult if you don't actually get your hands dirty. Figure out, what I mean by that is figure out what the regulators have to do, what their day-to-day job is, and do it yourself to some extent. And then you'll better understand the efficacy of the program. And so with that change, it was looking back at the time, it was just, all right, let's start changing how we do things. We'll start doing actually direct exams of market makers, and we'll actually follow up on surveillance reports and kickouts ourselves. But it was a dramatic and unwelcome change from the SRO's perspective, right? Because I think the regulatory leaders at some of the SROs, I think, almost played a middleman, and again, I hate to say this, but I felt it at the time, but almost were protecting their membership from kind of direct SEC involvement and regulation. So when, again, one exchange, we went in and said, hey, we're going to start doing direct exams of your members, and there was shock, like, oh, even to the point where, like, the head of the program said, I don't think you can do that. When, of course, I was like, yes, these are registered broker dealers, right? Of course we can do it. So, but again, that shock to the system was healthy on a variety of ways, and I think it's healthy for the inspection program because I think it invigorated a lot of people on the team. Because again, that original kind of check the boxy, pure oversight inspection, way of doing inspections, ultimately got, wasn't as rewarding as it probably could have been. But when you're actually kind of getting your hands dirty, learning how these regulatory programs work, learning how trading works, I think it's a lot more rewarding for the people who on my team, and then just a much more effective oversight program.
Yeah, because people are getting to actually inspect trading rather than inspect a program.
Yeah, inspect someone else who's
abstract.
Inspecting trading, which
Right.
is, yeah, and again, and I never appreciated two things: how until after we implemented how invigorating it would be to my team. Like, it's just improved morale. I think it was much more interesting place to work because you had that hands-on experience. And then the findings we made around the deficiencies in the SRO's programs were much more powerful because we could support them with, again, the information that we collected during the hands-on part of the inspection. So it, even though it seemed incremental and at the time, it was a dramatic change in the inspection program, and ultimately I think a significant improvement in both kind of forcing better regulation on the SROs, and then obviously we were able to root out a lot of problems within the industry that ultimately protected investors in a profound way, in my judgment.
So you've still got to do the oversight exams as well. How much, where did you divide it up? Was it 60-40, 75-25?
Yes, probably, it's a good question. So we would, always, say we do an inspection of the New York Stock Exchange insider trading surveillance program. So we would probably do, like, cut back on the oversight, the typical oversight inspection process, right? We would look at fewer files, et cetera. But then we would dramatically increase resources on, we would look for kickouts ourselves, as an example. We would review reports and see whether they were properly followed up on, et cetera. So I think at the end of the day, it kind of got integrated, the inspection program and the direct, and more kind of the hands-on part of the inspection got integrated. But I think it ultimately probably was about 50-50 to kind of answer your question directly.
Okay.
Yeah.
Great. Well, let's move on a little bit. You worked on, one of the interesting things is the function of OCIE in helping to make policy or informing policy. And Reg ATS is coming in at this point. Order handling rules are coming in. Talk a little bit about how the inspections that you were doing helped inform those efforts. Yeah,
I mean, obviously the policymakers would, I think they would my recollection is the most interaction was after the rules were first implemented, meaning the limit order display rule is a great example. That was a dramatic change in the requirements on how a specialist or how a NASDAQ market maker had to handle a customer limit order. And I think that putting the rule on the books, changing the speed limit from 95 to 55, that's easy. But I think, and I'm proud of kind of how we collaborated with the Division of Market Regulation. I think kind of getting the industry not only to understand, hey, there's a new rule that you have to comply with, but ensure compliance with it in short order is what my goal was. And having collaborating with the Division of Market Regulation and having them kind of, constantly support us in our, relatively aggressive, ensuring implementation of these rules was a great. I remember those days. It was a great collaboration that I think ensured compliance in a much quicker way, and I think historically a lot of rules would go on the books and there'd be a kind of a ridiculous amount of runway before they would actually become complied with. And those days were over under Arthur Levitt and Rich Lindsay and Lori, and I think that was a dramatic shift in the perception around how rules are implemented and how rules are expected to be complied with right away, and that collaboration between OCIE, in this case Market Reg, I think proved very valuable, ensuring that those orders, which are fundamental customer protection rules, were complied with right away.
This is an interesting concept. The SEC historically, the inspectors sort of prided themselves on, yes, going in and being the tough regulator if you needed to, but also just providing help, saying, hey, here's what you need to comply with, here's how you comply. Mm-hmm. How much of that kind of work did you find your group doing? How much was friendly assistance?
It's interesting. So the order handling rules were, for instance, limit order display rule, but it also set up the ECN framework, which was a completely new regulatory framework. And that was, so I was responsible for both. And the ECN's inspections, and there were originally 4 ECNs, like Island, Instinet, Bloomberg, and Archipelago. And those inspections were much more, to your point, much more, hey, John, how do we do this? Like, what's the expectation here in this rule? And I think collectively, those 4 initial ECNs wanted to. There was no question about kind of wanting to comply and have the spirit of compliance, but it was a completely new landscape and new players in it. these were all, Instinet was probably the only established player. So I think that those inspections were often very collaborative. Again, we worked hand in glove with market reg to kind of help them understand what the expectations around these rules were. And there's also a little bit of, market reg was, when you create something new like that, it was also, you have to have an attitude, a little bit of a back and forth and collaboration, because, it's not quite sure, there are unintended consequences to some of these rules. I mean, one anecdote to show you the brave new world that world was. So we did an inspection of Island, and Island was an ECN that DNA came from, the SO's bandits and that whole ecosystem. And Island was started by people that kind of had incredible technological savvy, and were incredibly talented, but they were not Wall Street. Quite, I remember Josh Levine was, I was in my 30s, he had to be in his low 20s, right? So, and one example of, I'll never forget an inspection of Island, like Josh Levine offered, I was really fascinated by his Palm Pilot, like this is before obviously phones or anything. And I said, I said something like, I really like that. So he said, here, you can have it. And so to be in an environment that's kind of so cutting edge and bringing in players like people at Island or Archipelago, by definition, you had to have a collaborative attitude for it to work, right? Because these were people that weren't used to regulation, but ultimately wanted to change the markets. They wanted to electronify the markets, and these were some of the most talented people in the industry at the time. So it was invigorating for me and my colleagues, but again, accentuating your point that these were collaborative type inspections, as opposed to kind of the implementation of limit order display rule were more like, hey, new rule, and you haven't done anything to adhere to it. So very different dynamic during that period that was kind of up and down the spectrum. Yeah.
Do any examples come to mind about that other kind, the limit order display rule, for example?
Yeah. Again, never forget, I was on the floor of the New York Stock Exchange, and the rule, again, I'll be embarrassed to say I can't remember the exact language, but the rule basically says you basically are required to immediately display the limit order, but in no case more than 30 seconds, right? So, but it's like displayed immediately, and basically to a layperson, but it better never ever be more than 30 seconds. So, again, another example of collaboration with market reg. Went to the floor of the stock exchange, probably went to the post of one of the most volatile and high volume stocks, and again, I was with the head of surveillance, New York Stock Exchange surveillance, and I asked the specialist, hey, tell me about this new rule. Are you able to immediately display limit orders? Is compliance an issue? And he more or less said, again, he knew I was with the SEC. I'll never forget, but he basically said, I do my best, but I'm not gonna, they're mostly gonna be 30 seconds. And I go, well, but then I said, of course, naively, but the rule says immediately. And I go, well, it says 30 seconds. You talk to, and they pointed to the head of surveillance. But I think that moment in my career was an important one because, even at that relatively young age, I knew a specialist should not be speaking to an SEC attorney with that level of cavalierness around complying with what was then a very high profile rule in front of his head of surveillance. It was frankly, in retrospect, absurd, insulting to the New York Stock Exchange regulatory program for him to do that, and it spoke volumes around that relationship. And then for me, it was like, okay, we have a fundamental problem if they're taking me to one of their most seasoned specialists that's saying he really has a cavalier attitude toward complying with the new rule. It meant that at the time I was thinking we have a fundamental problem that we have to address. And I spent a lot of my career after that focus on that exchange and focus on their regulatory program and ultimately with the goal to protecting investors and improving it. So, but again, it's amazing what a single conversation probably took less than 20 seconds, how a single conversation can have a profound impact on me, on the New York Stock Exchange regulatory program, and ultimately on the exchange itself. So.
Yeah. Anything else we should talk about from that first period that you were with the commission?
Yeah, so the order handling rules implementation was big. We focused on that. Yeah, no, I think that's
okay.
That's good.
Why you talked about how invigorating this was. It was a neat job. You're learning a lot. Why the decision to go to Knight Securities?
Yeah, so it's the decision to go back to. So
yeah.
So the person who hired me into the SEC, a guy named Mike Dorsey, he became general counsel of Knight, and so basically he, aggressively kind of courted me and really wanted me to join Knight, which was at the time literally, transforming the way customer retail orders were being executed, and they were, Knight Securities was a manifestation of the proliferation of online. Again, don't forget the internet was relatively new, of orders being entered online. So Knight basically became a consortium of the online broker dealers, the Knights of the Round Table, and it was basically at the point, really at the a leader in kind of this revolution of how retail orders were being executed. So it was obviously for me an exciting area to potentially work in, but to be honest, so you had someone courting me plus an exciting area, but I didn't really want to leave, right? And if I look back and being honest, and so I went up to Knight Securities. I only was there for 3 months, but Arthur, obviously at Lori's impetus, called me. I'm a young lawyer at Knight. I get a call from Arthur Levitt, right, which is of course crazy. So he called me, and then I'd say, I'll call you back, and I went outside. And I remember Knight was in Jersey City. I remember looking at the river, Arthur Levitt saying, hey, you should really consider coming back. Lori, because I had insinuated to Lori that I wasn't that happy. You really should consider coming back, and there's a lot to accomplish here. It's Arthur Levitt, and so so like I came back because basically I got that phone call to in no uncertain terms, and that phone call started a lifelong relationship to this day with Arthur Levitt, who's been an important part of my life, both as a colleague and as a friend. I really view him as a friend. So that phone call, even though I met him a couple times before, that phone call was my first one-on-one interaction with him, and it was now turned into a lifelong relationship that was incredibly important to me. So anyhow, your question is why I left, but I'm really focused on why I went back. So.
Yeah, well, it is a very, very brief punctuation there.
Yeah.
It's a comma.
What's funny, sometimes I fill out where have you worked, and sometimes I omit that or forget about it. But it was I think it showed two things. my passion for work, obviously the money was more, of course, at night, but my passion for working at the SEC and how much I enjoyed that job, it was such an easy, just getting a little bit of an impetus from Arthur was all I needed, and I aggressively came back. So it was like it wasn't a hard decision. Ironically, it wasn't a hard decision to come back, even though I don't know how many people come back to the SEC after 3 months, but it's probably a short list of.
I haven't met any.
So I like being on a short list of crazy people. But
well, there you go. So you became associate director of market oversight. Is that the title?
Yeah. So when I came back, that was my new position. Right. Right.
Was this a created position where it had Lori kind of and Arthur sort of talked about doing something new here? Yeah,
I think it was. I think that's fair. I mean, obviously, it still had some of the oversight responsibility that would always existed, but I think its focus was on trading, best execution, and oversight of the inspection programs. I'm sorry, the SRO programs in those areas. Yeah. So it was basically a new focus and a new carved out area.
Okay. Payment for order flow. That was one of the things you dealt with when you came back, right?
Yep.
Talk about that one. Sort of when that became a hot issue for you.
Yeah, I mean, payment for order flow is one of those, literally to this day, you pick up the Wall Street Journal, it's one of those issues that has more than 9 lives. But I think Arthur and the chairman's staff were particularly focused on that issue. I remember Joe Lombard, who worked for Arthur, was, again, particularly focused on the issue. And again, payment for order flow, when I first focused on it in exams, I remember we did an exam of, I think it was E-Trade, and we would talk about payment for order flow, and E-Trade's attitude was, hey, we send it whoever pays us the most money, right? Which we were pleasantly surprised to understand that you can get paid for order flow and create a whole revenue stream. So I think that the kind of regulatory push to ensure that, hey, you can't just send your orders to someone just because they pay you the most. You're required to get best execution. I think that it's been a long kind of uphill battle over time. But again, when I came back and was head of market oversight, I think it was co-commit with kind of a focus by the chairman. Obviously, he was uber focused on all things that affected, the retail customer. So payment for order flow was really on the top of the list. So we did sweep exams, I think we called them, sweep exams in that area that was, it's probably one of the prouder group of exams that I did, because I think we found serious issues and serious flaws that were costing retail investors significant amounts of money. But we also, I think, did the work in such a way to really allow the policymakers to understand exactly what's going on and to give them, give them kind of the foundational facts to start addressing this from a rulemaking point of view, be it at, in this case at the SRO level, FINRA did rulemaking. But again, I think that it was really one of the first times where I knew that the information we were gathering would possibly result in enforcement cases, but also be the foundation for the policymakers, be it at the NASD or market reg, to kind of improve the situation, which did happen to some extent.
You used the phrase sweep exams, which was one of the big OC initiatives, one of the things that first appeared there.
Yeah.
Talk a little bit about what that meant, how you did them, and why it was different.
Yeah, so a sweep exam, you would typically identify a practice in the industry that you thought or you had some information that was somewhat widespread, right? And so rather than kind of doing, clearly they were also, focused exams on typically one issue, rather than kind of doing those type of exams as part of your kind of routine exam program, I think that there was a perception, I think very rightly so, that if you focus in on one issue and focus in on all the players that were likely to be affected by, it was, I think, fairer way to employ examination resources. So you weren't kind of targeting, but randomly a handful of firms. You were targeting all the firms that were paying out. Receiving significant amounts of payment for order flow. You were doing it in a targeted way, and then you were also doing it in a way that would get the results much quicker, right? So, so I think my first group of exams that would fall in that sweep exams was this best execution one. Yeah.
And did that involve the options markets in particular?
That would have been the follow-up, yeah. So we
Okay.
would have then follow up in which we looked at the payment for order flow in the options markets as well.
Was that a particular problem at CBOE and some of the other options markets?
Yeah, it was, and then again, I think we were able to focus, through this kind of sweep dynamic, we were able to focus on a payment for order flow in options, and again, their options were always kind of redheaded stepchild of both, the focus on regulatory resources at the SEC. So I think it was a really important group of exams in that regard, because there's the similar conduct as in the equity side, but probably turbocharged, probably kind of worse in many ways.
Okay. Well, backing up a little bit, OCIE grew pretty quickly during this period. Resources was always an issue, but during this point, OCIE is getting more resources than it had for some time. Can you tell me a little bit about the training program, how you staffed up, the kinds of people that you hired, and how you brought them up?
Yeah, so training for Lori, training was very important, right? And I think when I joined the commission, it's there wasn't really a formal training program per se. In fact, I remember, the extent of training, as it were, was we would, I think, had a monthly meeting with an SRO who would come in, and there would be, I think, kind of hot topics was what the training meant. But what that was an opportunity for the SROs almost to lobby, albeit young staff, lobby them on the issues of the day. I remember New York Stock Exchange was lobbying on how important the eighths were to the markets. And again, I sat through this presentation. It's like the Spanish dollar. They were saying it goes back, and kind of lobbying me. Again, just way down the learning curve. Didn't really understand the issue that well, but I knew it didn't feel right to have them the opportunity to kind of lobby us on it. Lobbies. I think it was not called lobbying, obviously, called seminars or education seminars, but again, it didn't feel right, and so I'll always remember that when kind of fast forward to being associate director with Lori, that the importance of training, given my experience when I joined the commission, I definitely agreed wholeheartedly with Lori how valuable and important it was. So when we brought in, we hired, I think, only staff attorneys, but training and the importance of training was always a priority. So.
Did you ever bring in accountants, people with specialized skills like that?
Yeah, we certainly had. I think there were accountants, not that I hired, but already on staff that worked in kind of the market oversight program. But yeah, so we did have some, but the preponderance was attorneys.
Okay. So one of the things that comes up is the moving from sort of, I guess it's a cyclical approach to doing examinations to risk-based examinations. And you talked about, targeting somewhat, but that's maybe not exactly the same thing as risk-based. Can you talk a little bit about the context to that, why there was this shift to risk-based examinations and how that worked?
Yes, that's a great question. I think, again, when I joined, and I think this was a common term, a common term that Lori used, but I could be wrong. But I think there's a mentality or culture of more kind of check the box, like routine, check the box exams, and when I after I became an associate director, I certainly realized that the inspection program was suffered from that kind of mentality, and that was kind of the foundation for trying to change the methodology and kind of get what I call the hands dirty and do actual exams of either the firms or of the surveillance, do actual reviews of the surveillance reports, et cetera. So I think from my experience in the oversight program was helpful for Lori as she was moving the exam program from this kind of check the box mentality to a more risk-based, better use of resources. Again, I call it targeted. I think targeted and risk-based are kind of similar, but I think that the oversight program was maybe a precursor to Lori's implementation of that really cultural shift within the entire program.
Okay.
And then, of course, the exams under me, which were kind of primarily focused on trading reviews, best execution, whatnot, they were all, by definition, focused on a single topic, and we will always scope them in a way that was very targeted for what we thought was a problematic conduct in the industry.
Right. You're focused on trading, and which is great because a lot of the focus when you talk about OC, people think of broker dealers.
Yeah.
How much did you talk to the broker dealer exam people? Was there cross fertilization at all between those two sides?
Yeah, for sure. And a lot of the, when you're staffing on sweep exams or a lot of even kind of our routine best execution exams, we would depending on people's workload, we kind of cross fertilize by definition. Part of it was, I think, that the exam, my exams or the exams under my program, I think we're generally we're sought after because it was kind of generally an interesting topic and trading and et cetera. A lot of people joined the commission wanting to understand markets better, and kind of what we were looking at was kind of the heart of kind of the how the markets function. So I think definitely cross fertilization was common, and it was relatively easy because people generally were more than happy to add one of my exams onto their portfolio. So pretty common.
So speaking of broker dealers, it was interesting to see that you were involved with one of the early exams of Bernie Madoff, because you're a markets person. How did you end up looking at Bernie Madoff?
Yeah, again, Madoff was, I think, the biggest or one of the biggest third market makers, so over-the-counter market makers, and the third market was he traded listed stocks, New York Stock Exchange listed stocks. So we did, for the exam of Madoff, it was, again, a target exam of third market makers. I think we had a theory of the case was, determining whether the third market makers who had, pipes of retail order flow coming in, whether they're using that information in a way that kind of could harm the retail order flow, using that information, but in essence front running it in their if they also had a proprietary arm, or in his case a hedge fund. So I think we were basically looking at whether there was any correlation between the information they're gathering from their retail flow with their proprietary trading. And and Madoff, obviously that was not what he was doing, front running retail order flow, but obviously he was doing a Ponzi scheme,
Right.
as we all know.
When was that examination, the front running examination?
I can't. I'm guessing 2005, 6, something in that range. Yeah.
Yeah.
Actually, probably a little early, probably 2004. Yeah.
Okay. Yeah, and so obviously, as we found out later, that wasn't the case.
Right.
But what does that suggest about the weaknesses of the OC program, or things that could have been?
Yeah, obviously, many thought about this for many hours. I think as I look back, the exam itself, the targeting in this case of the targeting, that the exam itself made sense, and obviously Madoff was one of the biggest third market makers. So we were getting information, that people were hypothesizing that could be done. So the exam itself, I think, went as I would have expected. I think that as I look back again, obviously with 20/20 hindsight, one thing that Lori and I were passionate about was supporting examiners who wanted to think outside the box, who wanted to say go in a different direction. This was kind of the anti-check the box mentality. So it was a lot of effort and a lot of time was put in by myself and by Lori and others to change the mentality, to change the culture of the exam program and the inspection program. And I certainly feel like we were successful in that. But obviously in the Madoff exam, there was the opportunity for, if something seemed a little screwy, I want to go in a different direction. Obviously we would have supported that. So the Madoff exam had the potential, had one of the examiners wanted to go off in a direction, there would have been no friction in them doing that, and obviously had they done that, certainly would have been possible. They would have uncovered the Ponzi scheme. But again, to expect examiners to kind of go in a different direction or change the scope of the exam on the fly is takes experience. It takes it takes confidence, and ultimately it didn't happen. Obviously, I wish it did, and it's one of those things that there's obviously a certain level of frustration, but again, I think if I was being objective, I think we did a good job in changing that culture, and there was one of the things that it had the chance to work in that context. Ultimately, it's fine that it didn't. The exam that they focused on went exactly as it should have, but it was an opportunity missed, I guess.
Right. Well, let's talk about some other notable events that you got to deal with. The investment banking research analyst conflict of interest scandal, and here we got Elliot Spitzer bringing this one up, right?
Yeah. I mean that was again. I think Alex Spitzer first found kind of this conduct in Merrill Lynch or Blodgett comes to my recollection, but ultimately it turned into the first time in my career, and maybe the first time ever, a kind of all hands on deck, all securities regulators, attorneys generals, FINRA, SEC, and the states kind of coordinating on a massive sweep, to say the least, in a short period of time to try to identify the prevalence of what I guess Spitzer identified in the Blodgett Merrill Lynch situation. And again, for me personally, it was frankly a lot of administrative herding cats. I think state regulators some are very seasoned and sophisticated, and some aren't, and you kind of had to deal with a dynamic that was, incredibly complicated. But I think the resulting report, resulting exam findings is done in an incredibly short period of time, and the results were extremely high quality. Something I'm proud of, but for me, it's not. I can't say I enjoyed it, because it was literally, I remember herding cats. Like, it was, they can't. There's a snowstorm in South Dakota. We can't get to the exam on time. So it was that sort of kind of dynamic in place. But it was an example, I think, really give kudos to Lori, where she's able to take a leadership role in the industry at its whole. And again, I was part of it, but it was a great result. But again, easier said than done, that's for sure.
So you worked with the SROs,
Right.
State examiners. We haven't talked much about the regional offices. You must have worked with the regional offices on this as well, right?
Oh, yeah, for sure. Yeah, regional offices were incredibly important in that exam, for sure.
Yeah. What was, did the role of the regional offices change under OCIE? Was there a new look at how you would use regional offices?
Yeah, I mean, for my group, the market oversight, it was all kind of self-contained. Certainly when we went to do an exam of E-Trade in California, we would often bring again, an example where we would collaborate with the broker-dealer program. We often bring them on those exams and help because they would have some familiarity with firms in their region. But from my perception, the regions were kind of more outside my core competency, but Lori, I think, did a great job in empowering them. Again, kind of giving the same thing that kind of OCIE was for me. I think Lori did the same thing for the regions, kind of empowering them to really, have the ability to step up and act in a more autonomous, just a lot. I think that, from my perception, the performance of the regions improved dramatically over time with kind of the general empowerment, same thing that OCIE did for the exam program coming out of Market Rate.
They had a lot of responsibility for the broker-dealer
Right.
inspection, certainly. There were still a handful of regional exchanges out there, though. Did the regions sort of monitor those, or did you watch those from Washington?
So the regional exchanges, the self-regulatory programs were almost exclusively monitoring their members on the trading floors, right? And so we were responsible for that. Although technically some of them were broker dealers, and technically they certainly could have fallen under the exam program. But I think that was the area that part of the rationale for the formation of the market oversight program was to give a better SEC focus on what's going on at the regional exchanges at that broker dealer level, and we did focus in on those, especially at the options markets, which we put a lot of resources into reviewing the members in the options markets in addition to the regional exchanges.
Okay. Any notable regional exchanges that were particular problems or challenges?
Yeah, I mean, listen, they were all a challenge and a problem because they were a dying. Commercially, they just made no sense anymore. A lot of the fundamental reason why regional exchange exists in the first place was because technology at the time made it necessary to have an exchange in San Francisco, an exchange in Chicago, so to allow people to buy and sell, in this case stocks in those regions. But but quickly, even when I joined the commission, they were anachronistic, and their business models, frankly, were, frankly, made no sense, right? If you would certainly not start a regional exchanges. I think the biggest attribute they had was they had licenses to trade, and so Archipelago, one of the ECNs that I talk about, they basically merged with what was a dying Pacific exchange and bought that license. So again, it's an interesting question, but when you have these kind of deteriorating business models, it's not exactly a great situation for a regulator, right? So, these were self-regulatory organizations that were not doing well financially. So it was always a struggle for me as an overseer to ensure that they put an adequate amount of resources into their programs, which they struggled to do. Yeah.
All right. Well, that's a good one. And so we talked about the regional exchanges. The New York Stock Exchange is still the big show at this point, and you had the front-running scandal emerged, and you had some role in that. OCIE did. Can you talk a little bit about how that unfolded and what OCIE
Sure.
was able to bring to the stock exchange as it sort of tried to rebuild from that?
Yeah. So again, we were day to day overseeing the New York Stock Exchange regulatory program. I think we got information that that one of its specialists was front running customer orders. The lingo on the floor was dot arbitrage, right? So you had two customer orders, a buy and a sell, on the book at the same time. The New York Stock Exchange rule required the specialist to match those, right, at a single price. But this specialist was not. He was executing one at, say a penny difference, a buy and a sell at a penny difference, and he was making, in my example, he was making a penny on that each trade, and those pennies added up to millions of dollars of profit for the specialist that was a rule violation, right? So information came in that this one specialist was doing it to some extent, and I think what at the point in my career and my colleague Eric Swanson, the point in his career, we were at the points where we understood how trading worked on the exchange. We understood the surveillance systems and the monitoring systems, the audit trail that they had, to a pretty sophisticated way. So we were able to quickly answer the obvious questions. Okay, how often did it happen with this one specialist? And then what we did, the OCIE did, was conducting a group of exams and inspections. Group of exams to basically determine how often that illegal conduct that we knew happened in the one instance happened across the floor. And so, at the end of the day, we quickly determined, it was very interesting, factually, I think there's 30 or 40 specialists, say 35 maybe, and 15 did this illegal conduct and made significant amounts of money, and then the remaining specialists adhered to the rules. So as I look back at what we found and and kind of the frustrations that ultimately came from the New York Stock Exchange, it was an example where some bad apples ruined it for what were compliance specialists, and so answer your question. So we kind of determined what the scope of the illegal conduct was. I think it was hundreds of millions of dollars of ill-gotten gains, and so we then kind of went down the path of passing those findings on to the Division of Enforcement with the findings that the New York Stock Exchange should have done a much better job in surveilling for and preventing that dot arbitrage conduct. So there was an enforcement case against the exchange itself, and then then there's also enforcement cases against those 15 specialists who were the minority of specialists who were conducting the conduct.
Right.
So it was obviously big enforcement cases, but the inspection report that we wrote that basically outlined all this was frankly one of my proudest moments, in that it was a result of not so much obviously a lot of hard work to identify the conduct at the specialists, but it's the result of getting up the learning curve over 10, 12, 13 years of being at the commission and being able then to actually conduct a pretty complicated exam.
And
group of inspections.
Yeah, and there's the enforcement case to deal with, but the New York Stock Exchange has also got to reinvent or fix its own surveillance supervision.
Right. So they had the inspection report that became public. Inspection reports are not public, but they had the inspection report that was highly critical of their regulatory program, and kind of highly critical of how hard they looked for things, and also highly critical of how they, once they found conduct that was problematic, how they, I think the report said they, slap on the wrist, right? So there was not a very good deterrent effect. So I think that inspection report was a wake-up call for the New York Stock Exchange, and I think it resulted in extremely aggressive changes in their regulatory program to try to address and improve it.
Any idea how the inspection report became public?
No. I mean, I was shocked. It's in the Wall Street Journal. I was shocked to see, my wordings in the front page of the Wall Street Journal. But I don't know. I mean, yeah. It seemed that it's funny. It's a bit of a parlor game at the time, and even now, how it got public. But it could be anyone from the commission all the way to the New York Stock Exchange who had an axe to grind. And I would have, if I was to guess, I would say it's probably someone at the exchange side. But again, they said they kept it extremely tight. Not many people had the exchange, so I don't know.
Yeah, something people love to do in Washington.
Yeah, it's not the first time.
or the last. Anything else we should talk about from your associate director period?
New York Stock Exchange. Yeah, that was kind of the highlight. Yeah.
Great. Well, you also did an exam involving Knight Capital, right?
Yeah. So that's obviously we have the background, but I think Knight was an example of just kind of our routine best execution program, uncovering kind of egregious, again, in the go-go days of the dot-com bubble, the market was tearing upward, and kind of all bets were off in terms of any sort of ensuring that customers got the best price reasonably available. I mean, and so it was an exam that found kind of conduct that was way off the charts, that there were commissions of $1 a share, $1.50 shares, just crazy stuff going on. But what's interesting about that exam is, in kind of hindsight, certainly the conduct of what Knight was doing was problematic, but a lot of the orders were coming from institutional investors, hedge funds and mutual funds. And I look back at that exam, and one thing I kind of regret is I didn't focus enough on, the people who were sending orders were also fiduciaries for customers, and they were the ones getting these kind of crazy prices with commissions way off the chart. So I think in hindsight, best execution should include the conduct of people who are routing orders and ensuring that they're getting the right prices. And that's probably an area where yeah, I think we tried to get enforcement to bite on that, but I think that was an area that I wish I focused on more in hindsight. Because it would be a much more effective way to ensure that customers get the right prices, to put enforcement or regulatory pressure on the fiduciaries who are routing the orders to these market makers.
Yeah, good point. Did this come out of routine exams, or was this a matter of reading the papers and saying, we want to look at these people in particular?
I think the night exam, I think it was an arbitration that someone alleged that there was problematic execution quality or something like that. So I think information came I think through that sort of way, and then we started an exam. So it was what we call a for-cause exam. Like we had information to suggest problems. Yeah.
Okay. Well, great. Let's. Then you decide to leave the commission one more time.
Yes.
Talk about the opportunity. What took you?
Yeah. So I joined a firm called GetCo in Chicago. Again, it's a firm that was started just a handful of years before I joined. It's about 60, 70 people at the time. It's in a place no one has ever heard of. As an associate director, going to a place no one ever heard of, that was strange. But what's interesting as I look back now at my career and how lucky I was, I had a front row seat into where the markets were heading and what likely, who likely would succeed in kind of the electronification of the markets. And I knew a firm like GetCo was in a prime position to really benefit from what's an inevitable change in the markets from pit to the screens.
This is an electronic market making company.
Yep. And the founders, Dan and Stephen, were, they started in the pits, one in the Merck, one in the SIBO. So, but they had a vision that the markets were going to change and that the status quo was not going to last long. So I think they started before anyone else to start trading electronically, and there was kind of pit to screen, the original arbitrage pit to screen type trades that obviously eventually turned into pure electronic trading, and then by the time I was there, they were trading sometimes 30 or 40% of the SPYs in the market. So they were just early on vision of what the markets were going to become, and they took full advantage of it.
What was your position at GetCo?
I was general counsel.
Okay.
Again, even though I had a front row seat into this world and kind of knew the players, the general counsel of Island, which was the biggest electronic market at the time, he was a friend of mine, a guy named Cam Smith. So he knew the head of one of the founders of GetCo, and he said, "Hey, to Cam, do you know any good compliance legal guy for me?" And then Cam luckily said John McCarthy. So.
Okay. So you'd spent a whole career in looking in markets, and you're outside the SEC looking in during the flash crash. Yeah. Tell me a little bit about how GetCo responded to it. What your position was, and what you saw the SEC doing.
Yeah. So quickly, as the markets changed dramatically, the financial crisis was the first crisis.
Right.
It's in its name. And GetCo was a major liquidity provider in the markets during incredibly stressful and volatile times. And I think that one thing I'm proud of, and I really give credit to Bob Colby at the SEC, is during that crisis, my relationship with him, being able to being able to pick up the phone and say, Bob, hey, we're market makers. The short sale rule is not clear. It's anachronistic, but we're market makers in every way, shape, or form. Are you comfortable if we comply with the rule in this way? And having the ability to get that those relationships and kind of the answers in a very stressful time was incredibly valuable. And I think that it's a good, you often hear kind of the revolving door, negative aspect of the revolving door of a SEC employee going out to the private sector, but no one focuses on where those relationships that they had at the commission can prove very valuable, not commercially in a commercial sense, but very valuable to the markets, to investors generally. So that was a really important. I feel really good about that period, that my role in that at GetGo in that financial crisis, because if I didn't have those relationships, then the liquidity that GetGo provided would have been more cumbersome, more full of friction, and would have been potentially problematic for the markets, because GetGo was such a big player in the markets at the time.
Was that the case during the flash crash as well?
Flash crash, similar situation. I think that on some level different in the sense that the SEC was then trying to figure out what happened and how it happened, and that's again an example where we GetGo have such a good understanding of the markets and what likely happened. We were able to kind of provide some valuable insights quickly, not only so the SEC could understand what happened on that particular day in May, but also to prevent it from happening again. So again, we were one of several firms that I think they collaborated with to collect information, and again, very helpful. I think in this case, the Division of Market Regulation, kind of very good at listening, hearing people's perspective, getting trading information, and kind of doing the right thing in a short period of time.
This has been a really interesting talk because, as I mentioned, when you talk about OC, it's usually broker-dealer inspections, investment advisor inspections, and I think the market side is really important. Anything else that we've missed that we should talk about from your career?
No, I think whenever I ruminate on my career, my father, what little advice I could get out of him, he would always say, it's always good to be, he was a military guy, but say, if you're getting flack, it means you're doing something right? If they're shooting at you, or whatever his militaristic metaphor was. So I feel incredibly lucky that I was at the commission at a period in market history that was, no matter what anyone says, was a pivotal time, and to be in a position where I was literally at the point of the spear of that change was, I realized how lucky I was, and all the people I've met as a result. It's just been a wonderful experience.
Well, that's a great note to wrap up on. Thank you very much.
Thank you. Thanks for your time.